Good morning, everyone, and welcome to the first risk reduction, risk management class of 2024. And hopefully there'll be some very, very good information for you in this class. I appreciate all of you who regularly attend these sessions. As a benefit to you, we will pick up the first half of the E&O deduction for agents who regularly attend these classes. So in addition to learning something, I hope you also, if you ever do need to take advantage of our E&O, some of the deductible Mike will cover as a reward for making an effort to stay current with the laws and the regulations. So, and I'm always grateful that you come on board on these calls, because clearly, if you're going to give up an hour of a very busy schedule, my goal is to make sure that hour is worthwhile for you and you get something out of this. So with that in mind, let's jump right into today's session. Let me share my screen. I think I remember how to do this. Can everyone see my screen?
Yep, we can see it.
All right, let me get all right. So as always, I start out by being sure you know how to reach me. During business hours, my direct line, the 7115, is probably the best line to call. Although I have my cell phone on and I keep an eye on it, during business hours, I don't do a lot of business on the cell phone, so the direct line is by far the best during business hours. Email me at any time. That's my email address on the screen. And then weekends and evenings, as most of you have probably heard, I honestly believe that if you're working, I should at least be available. So never apologize, never hesitate. If it's evenings or weekends, if I'm in the middle of something and can't take the call and don't want to be interrupted, trust me, I won't respond. But usually I'm available and I keep the cell phone nearby. I do keep the ringer off for personal reasons, for my wife. So it's best to text me because the texts alert me and I see them on the phone and then I will call you. So there's my cell number on the screen there. All right, let's jump right into today's class. We're going to talk about the 2024 new laws. There's a lot of new laws. But I'm going to talk about 6 or 7, I think there may be 7, that are most germane to your day-to-day activity in real estate and that will have an impact maybe in some way on how you conduct your business. So I want to review those laws with you. Nothing earth-shaking, I don't think, but good information to have. We're also going to do another review of the FHDS. It's a complicated form, and how to fill it out. You know, I honestly believe that agents struggle with it because there is so much misinformation out there, and much of the misinformation, if you will, comes from authority figures. And even as recently as this week, I talked to Carr about the FHDS and some of the questions that come up on it. And what I'm going to tell you remains what I've been saying for a while. It remains true. So we're going to go over that briefly. In the handout, if you haven't accessed it yet, you'll see a summary of what you need to know. And I want to kind of review that with you quickly. So let's jump into the new laws. The first law that doesn't have a big impact, but for your information, AB 225 is a statute that authorizes an update of the environmental hazards booklet. So that booklet's going to be updated, and it's going to be updated as resources permit. The law was structured, actually the law was proposed by Carr, and Carr was sensitive to the fact that they didn't want the government to incur additional costs. So they structured it in a way that allows private industry to contribute to the update of that booklet. And so that's what we mean by as resources permit. So when private industry comes forward and updates some of these sections, it'll be incorporated into the environmental hazards booklet. 3 new chapters will be added, one covering wildfires, very, very germane, of course, climate change, a hot topic, and then sea level rise, certain portions of California, and coincidentally, the most heavily populated sections of California are projected to be affected by potential sea level rise. And so Carr, in keeping with the times, has suggested that information be updated, provided and updated in the environmental hazards booklet. So as I said, the booklet will be updated when resources are made available, and those resources are probably going to be from private sources. There's no date for when these updates will occur. It's not prescribed in the law. So, when you get the booklet, presumably always get the booklet online. Don't store one on your computer for too long, so that when it's updated, you'll be aware of it. You'll be giving out the updated booklet. And I'll keep my eye on it as well and alert you in one of these meetings that the updates have in fact been done. Okay, a big issue, and I would argue that not a lot has changed here, but there is a benefit, obviously, to AB 968, which we're going to call flipper disclosures. Lots and lots of problems. I can tell you, maybe, I don't know, 50% of the very serious claims that I'm involved in, there's more than a few, some of them reduced to lawsuits, involve flippers. So flippers is a very, very sensitive subject. I've talked to you in the past about Mike actually pays a premium to allow flippers within our organization. Some of you on this call, we have several agents that do flip property, and E&O companies don't like to insure flippers. We have some systems in place. I was able to convince our broker to go out with our systems and promote that to the various companies that we got quotes from, show them what we do in-house as to why it's not a huge risk to include coverage for flip properties. We do pay a premium for that, and there is a policy. So if you are selling a property you own, or relative owns, whether it's a flip or not, a flip is generally considered to be any property that sells within 18 months of its acquisition. So even if you don't do any repairs to the property, it's still considered a flip by authorities if it's resold within 18 months. We have some procedures that are outlined in Agent Hub. If you're selling a property that you own or a relative owns, and the definition of relative is very broad, give me a call, give Lindsay a call. She can direct you to that information, and I'll answer any questions. Let me talk a little bit about the law, and then let me go a little further about good procedures. Okay, so the law covers flippers of residential 1 to 4 unit properties. So that's what it covers. And the following applies to the transactions. They have to be 1 to 4 residential units, as I said, and the seller accepts an offer from a buyer within 18 months of the close of escrow on the seller's acquisition. So it's not 18 months from close to close. It's 18 months from the seller having closed on the property when they bought it, and they accept an offer from a buyer. So this law goes into effect within that time period. Much of this law is already part of civil code, part of disclosures, as you're going to see in a minute. Okay. And then the law covers any renovation or repairs that were performed by a contractor hired by the seller. There's been some debate already as to the legal definition of a contractor. From my perspective, and I think courts might evolve to this, there are contractors and there are licensed contractors. And so the very fact that there's a distinction between them, I think causes the probability that handyman can in fact be considered contractors. They're just unlicensed contractors. They're performing work on the property. So the law doesn't say licensed contractors. So I would say that this law could quite likely apply to handymen as well. So a seller hires a handyman and has work done, and then would claim, well, this law doesn't apply to me. I didn't hire a contractor. Well, even if this specific law doesn't apply to them, I think it does, but disclosure laws apply to them, as you're going to see in a minute. I hope I'm not confusing you yet, but this will sort of come together in a minute. All right. So the seller is required in this law specifically to disclose any room additions. Well, that's already a requirement, but this law makes it specific to flippers. Structural modifications, again, that's already a requirement, but it makes it specific to flippers as well. Any alterations to the property and any repairs the flipper does to the property. If you look at this list, you're going to say, those of you who are pretty sharp, and I would say all of you are, that's one of the reasons you're on this call, to stay sharp. I hope you'd look at this list and say, well, all those things have to be disclosed anyway. Well, and that's exactly true. That's what I'm going to refer to in a moment. Okay. A seller is required to provide copies of permits, if any, pulled by the seller or contractor. If the seller doesn't have the copy of permit, the seller has to provide the buyer contact information of who did in fact pull the permit. And then finally, the name and contact information of any contractors who worked on the property. The flipper disclosure law, AB 968, falls within the TDS law, Civil Code 1102. So what does that mean? That means that it has the same exemptions. So if you're exempt from a TDS, you're exempt from this flipper law as well. And making affirmative disclosures, answering all these questions on TDSs and SBQs. If you are exempt from a TDS, you're exempt from providing the form. You are not exempt from disclosing material information that you know. And no seller of any property is exempt from disclosing material facts. So this exemption really applies to providing forms, if you will. Okay. Now, the more important point, I think, especially sellers should keep this in mind. The flipper law, because it's part of 1102, has the same cancellation rights as a TDS. So that clearly, the law clearly establishes that once a flipper provides information to a buyer about the improvements they did and about who they hired and about the permits they pulled, the 5-day right of rescission kicks in. So that strengthens a buyer's right to cancel once they are aware of what the flipper has done, and it sort of lights a fire, or should light a fire, under sellers who are flippers, to be sure that these disclosures are made early in the transaction, because that 5-day right of rescission cannot be revoked. So that's, I think, an important concept. So the law goes into effect on any covered sale, in other words, any non-exempt sale, where the buyer accepts an offer, or the seller accepts an offer, from a buyer after July 1 of 2024. So the law is not yet into effect. But again, and you're going to see it in a moment, much of what's required in this law is already part of what's required under disclosure statutes that have long existed in California. And the good news is most of you are not going to be surprised by what you're going to hear here, because you're aware of this. If you've talked to me, I'm guiding you on what flippers have to disclose, not because there's a flipper disclosure law. There wasn't one. It's just that there's a seller disclosure law. and all of these things that flippers do constitute material facts and have to be disclosed. After July 1, it's going to be a little easier to convince flippers that they have to provide this information because it's now well documented in civil code. Some of the forms, CAR does not believe any new forms will come out as a result of the flipper disclosure law, but they do think they'll modify especially the SPQ a little bit. We're going to look at the SPQ. Repeating myself, I will argue the SPQ already goes a long way to accomplishing what is required under this law. Why? Because much of this, one could argue, was required under previous disclosure laws. So the current versions of the TDS, SPQ, and even the ESD, that's going to be pretty rare, already contain many of the questions that are applicable to flippers. So let's take a look at them really quickly. So the TDS, I gave you page 2 in your booklet, and page 2, section 2, that which the seller fills out, already talks about, did you get permits? And if you made repairs without permits or made alterations or repairs without permits that were maybe required, that you'd have to answer that question. Likewise, if you did anything not in compliance with building codes. And one of the things in the building code is getting permits to doing certain work. So that question already alerts you a little bit relative to permits on the TDS. I think the SPQ is far more informative, and sellers, especially flippers, but all sellers, should take very seriously. It is very, very important that you give the DIA, the Disclosure Information Advisory, to the seller with the blank copies of these disclosures for the seller to fill out. And you should perhaps review, not perhaps, you should review the DIA with the seller a little bit, as it explains the importance of answering all the questions on the TDS, the SPQ, and the ESD. So let's look at the SPQ. Paragraph 5 of the SPQ states that all documents, inspections, warranties, even estimates, surveys must be provided to the seller. And so, right there, permits is a part of the documents that you must provide, but anything else. And so those of you who have talked to me about buying flip properties, I advise you to always in writing ask the seller to provide any inspections and reports, any information, any investigation that they performed, they being the seller, when they acquired the property. And then pass that on to the new buyer so he can look at that. And so that's well documented, well detailed in the SPQ. Insurance claims. The SPQ already talks about insurance claims. Now here's something I'll share with you. A lot of agents don't understand this or don't realize this. It is not insurance claims filed by the seller. That is a critical piece of information. The seller is required to disclose any insurance claims within 5 years that they're aware of. So a seller is selling a property, i.e. a flipper, after having the property for 6 months and is aware that the previous owner filed an insurance claim, that seller must disclose that. It's not insurance claim. Notice it doesn't say filed by seller, made by seller. It's any claims affecting the property. Also, there's a provision in paragraph 6 asking for material facts, any information that either adds or detracts from the value of the home or informs the seller, informs the buyer as to the suitability of the property to be used in the manner that the buyer chooses to use it. Okay. Paragraph 7 talks about repairs and alterations. So there's already questions about that. And of course, if you made any repairs, alterations, improvements, you check yes, and then you provide an explanation. And the text overflow addendum works with the SPQ. And so, they can provide as detailed an explanation as possible, and it'll appear on the overflow addendum. Paragraph 8 talks about structural systems, including past defects. I would argue that a flipper really has a very high requirement to disclose, because they have to disclose any past problems. So, and a flipper's not going to like doing that because they're afraid the buyer will not want to buy the house because the roof used to leak. Well, the buyer's entitled to know that. And hopefully the flipper made good repairs or hired a good roofer to put on a new roof. But any past defects must be or should be disclosed. And failure to do that, by the way, constitutes a cause of action by the buyer against the seller. Number 9 is any relief, and it includes insurance. And where is the phrase right here? Past or present owners of property. See, they actually do a little better job there explaining. We're not talking about insurance claims that you, Mr. or Mrs. Seller, filed. We're talking about insurance claims filed by any past or present owner, past owner of the property. Finally, water, paragraph 10, water-related mold issues, if they're aware of any of that. Pool, any repairs to the pool, any issues with the pool in the past, that disclose that. Flippers flipping a house with a pool and they made some repairs to the pool. They need to talk about past, see that word past, or present defects. A lot of flippers don't take that very seriously. If you are a flipper or represent a flipper, you should take some time to go over this with the flipper. And I would argue disclosures made during escrow usually won't kill the deal. I mean, if there's serious problems, and they would kill the deal, imagine what they will do when they're discovered after close of escrow. Disclosures not made during the deal, during the transaction, and then later discovered, I can promise you, is going to be a major, major cost, headache, liability to the seller. So disclosing these past defects, flippers don't like that. I can tell you, I've talked to a lot of flippers and tried to explain this to them. You're better off disclosing it than not. Okay, water-related mold issues. I went backwards there, I'm sorry. Now, once again, material facts is highlighted in paragraph 18. On the SPQ, there's 2 places where they ask for material, where the form asks for material facts to be disclosed. So you can see the SPQ has a tremendous amount of information already pertaining to flippers, any seller, but especially to flippers, because they're obviously often fixing the property. Not always. Sometimes they buy it and then just resell it. But usually they're fixing it. Now, once in a while, an exempt seller might be involved in making repairs to a property prior to selling it. An exempt seller might be a successor trustee who the listing agent advised them, this house is a wreck. Maybe if you fix it up a little bit, and the trust paid for fixing the house up, you can, increase the sale price and provide a greater return to the beneficiaries on this property that they've inherited. So an ESD might come into play. It's pretty rare. And on the ESD, again, insurance claims not filed by the owner of the property, but any insurance claims in the past 5 years and any material facts that the seller's aware of. So those forms significantly already provide a high level of disclosure opportunity to the seller flipper and should be reviewed carefully by the buyer's agent and buyer to look in those areas to see what is disclosed. And if you feel like there are things not being disclosed, give me a call and I'll help you. In general, you want to ask flippers for in all the reports, inspections, investigations that they performed when they acquired the property, a list of all of the defects they repaired and what they did to the property, and then a list of who did the work and the contact information for those people. All right, AB 1280. This is a great, we knew this was coming and it finally has. It's a great addition to the natural hazard disclosure statement requirements in civil code. So what is that? What are we talking about? It simplifies identifying properties that are either in high or very high fire hazard severity zones. Prior to January 1 of this year, the law went into effect January 1. The new NHD reports already reflect the law. I'll show you a form now if you haven't seen one. But in the past, the statement, the natural hazard disclosure statement, that 2-page or 1-page form that was in the front of the report, only identified very high fire hazard severity zone properties. And then if it was a high, that would be buried in the report. What they would say on the report was whether or not there was a wildfire zone, if it's in a wildfire zone. And wildfire zone includes moderate and high. Well, so the problem was that if it's a moderate hazard, then the FHDS was not required. If it was a high, the FHDS was required, but the front of the report didn't simplify identifying that. You had to go into the report and figure that out. And many of you would call me and ask me, do we need to do an FHDS or not? And we'd have to look at the report. I would say, well, send me the report. Let's look at it together. We'll figure it out. All right. Well, now it's going to be straightforward. They've added 3 specific subcategories to high or very high fire hazard severity zone on the NHD statement. One of them is a high fire hazard severity zone, which was not on the statement before, very high in a state responsibility zone, or very high in a local responsibility zone. So here's what it looks like. That's out of one of our transactions right now. And the 6 zones are identified, right? Well, the middle zone there, the high or very high fire hazard severity zone, now is been expanded to include those 3 categories. So what you might have now is a property where right up front they're going to say it's in a high. They used to say if it was in a very high, so that was pretty simple. But when it was in a high, you didn't always see that right away. Now you will. If any of these 3 boxes are checked, of course, you have to provide an FHDS if the property meets the requirements for an FHDS, and we'll review that in a minute. And it's not an exempt transaction. So if the property is in any of these 3 fire hazard severity zones, an FHDS form must be provided unless exempt from a TDS. Okay. So the law went into effect. It's already in effect now. It went into effect on the 1st of January. So let's take a quick review of the FHDS. Go through it one more time. I think it's worthwhile for those of you that already get it. This will be a quick review. You can confirm, For some of you, you're still a little unsure. Hopefully, this will help you feel better about it. And the handout, if you haven't printed it already, it contains a summary. You'll see it contains some of these slides at the end here to help summarize whether, how to do an FHDS. Because the other thing is, do I provide one? Okay, yes, you do. Okay, how do we fill it out? And that's the more challenging aspect. All right, so let's look at it. There's the report or the disclosure and addendum. By the way, it's a disclosure and an addendum. It's also an advisory, which means it has to, it's contractual. And the law, if a property is affected, if it's in a high or very high fire zone, the civil code requires that the buyer and seller come to agreement. So paragraph 3 is the addendum portion. You'll see that in a minute. Okay, now with that form, it's a 2-page form. The FHDS is 2 pages. Most of you know that. And then with that is the DSDT. And Carr, for the first time, made me chuckle. Carr acknowledged that form's probably even more confusing than the FHDS itself. And that's been my belief from the get-go. When I first saw this form, I appreciated, I know the attorney who drafted this, and I appreciated his efforts to put this together, because the FHDS is a very hard form to explain to sellers how you fill it out. So this was supposed to help them do it. I have told many of you from the get-go, throw that away. That's not going to help you. It's going to confuse you. And the good news is Walt's prepared his own handy dandy way. Now I can do it. A car can't. Why? Because we sell very specific properties in San Diego County for the most part. So I can tell you what's going on in San Diego County. I cannot tell you for sure what's going on in Marin County, for example, or areas of other areas of the state. So CAR can't be quite as definitive as I am because they have to cover the entire state. I'm looking mostly at San Diego and southern, and LA County. Much of what I'm telling you is also applicable in LA County. Big Bear, it's not applicable. So if you're selling a property in Big Bear, give me a call. Okay. So forget that decision tree. So of course, the law applicability, let me review that with you again really quickly. We'll go through it. So the form is really two forms in one. And so the top of the form, paragraph 2 of the form, paragraph 1 is the applicability of the law. Paragraph 2 is the fire hardening disclosure. And so the fire hardening disclosure is required for sellers of residential properties. Residential, by the way, not land, obviously, contains 1 to 4 units. So the property contains 1 to 4 units so far, and it's in a high or very high fire zone. And that, I'm going to say that in a minute. The seller is required to do a TDS. So a successor trustee, not required to do an FHDS. The property is located in a high or very high severity zone. And the property was constructed before January 2010. So the fire hardening disclosure is applicable for properties prior to 2010. It's not applicable for properties after 2010. Why? Because what's contained in the fire hardening disclosure was incorporated in the building code starting in January of 2010. And so those questions don't apply. So if any of these 4 conditions are not met, the seller doesn't do the fire hardening disclosure of part of the form. Okay. Now, the defensible space compliance is similar in 2 of the, or 3 of the 4 ways. So disclosures are required for residential properties, 1 to 4 units. The seller is not TDS exempt. In other words, does have to do a TDS, and the property is located in a high or very high fire zone. Notice it doesn't matter when the property was improved or constructed, when it was made, when the improvements to the real property was done. It doesn't matter. So that 2010 provision doesn't exist. So if you're in a high or very high fire zone, and you're not TDS exempt, and it is 1 to 4 units, you do have to do the defensible space compliance, which is paragraph 3 of this form, regardless of even if it was built a year ago. If it was built a year ago, you don't have to do paragraph 2 of this form. All right. So what does paragraph 2 look like? Well, the 2A contains a statutory notice, but more importantly, 2B is a disclosure the seller must make. It's an awareness disclosure, much like a TDS. If the seller doesn't know, by definition, he's probably not aware. See, I don't know if I have soffit or roof ventilations with holes in excess of 1/8 inch. Well, then you're not aware that you do, right? No, I'm not aware that I do. Well, then you can say, no, I'm not aware. Okay. So those 6 questions, much like a TDS. Nobody really has too many problems with that form. By the way, they must be answered. Okay, when you get a form, when you have the buyer and they're not answered, they have not delivered the form. If you need my help, I'm happy to call the listing agent and with a very friendly way. I mean, I might want to recruit them someday, so I'm not going to irritate them. I'm going to see if I can guide them to help their sellers do what they're required to do. All right. The more important part of the form that causes a lot of confusion is a defensible space. So I can tell you any property in San Diego County that is in a high or very high fire zone is subject to local vegetation management requirements. Now, that doesn't mean the property that they have to do an inspection. Nowhere in the local vegetation management ordinance is there any inspection requirement, much less a point of sale requirement. But the property is, so sometimes I see this form and an agent will, or the seller will have checked is not. If you're in a high or very high fire hazard severity zone, and you are in San Diego County, I guarantee you, local vegetation management, probably more than one. There's a county, several cities have them as well. So you would check is. Then the next thing is the seller's representation of the property compliance. I would tell you that usually the seller is unaware as to whether he's in compliance or not, because he's not that familiar with the law, and he doesn't have a report saying that he is or is not in compliance. So the default, you'll notice no box to check. The default is the seller doesn't know. All right, now, if the property is in compliance and the seller is stating that, you must have a report. Protect your seller from making an affirmative statement that later turns out not to be true, and now the seller is on the hook for the problem. So the seller delivers that report documenting compliance within 3 days or. So you would only check is compliant if in fact you have a report that says it is compliant. On rare occasions, almost even more rare than B2, B3, the seller would be aware he's not in compliance if he had a report and the report said, by the way, you got a problem. You've got vegetation too close to the house or something like that. So again, a report, seller has a report and the property is not in compliance. There's no requirement in civil code for the seller to bring it into compliance. There is a requirement for the seller to disclose to the buyer if in fact the seller is aware he's not in compliance, okay? Not real complicated except 3A. I see that mistake from time to time. And again, once in a while I see a seller say, oh yeah, my property's fine. I'm in compliance. Okay, how do you know that? Well, it is. Well, have you got an inspection? Well, no. What inspection? Well, don't say it is. Go with the unaware boilerplate. All right. 3C is where there's most of the problems. And 3C, paragraph 1 is at the bottom of the first page. Paragraph 2 through 6 is on the second page. I put it all on one slide for you. And that's the agreement between buyer and seller on bringing the property into compliance. Civil code requires that buyer and seller agree on who's going to bring this property into compliance. It does not require that the seller bring it in compliance at a point of sale unless there is a local ordinance requiring that. As early as this week, or as late as this week, I guess that's a better expression, talk to CAR, and again, they told me of 2 areas. I happen to know of a 3rd area, maybe a little nervous, but it's kind of not quite the same. Truckee and Paradise do have point of sale requirements. Big Bear has a point of sale requirement. The reason CAR probably didn't mention them is their point of sale is not compliance, it's inspection. So Big Bear does require an inspection. It does not require the property to be in compliance. But the buyer and the seller have to agree on who's ultimately going to be responsible for that. So we're recommending when you represent the seller to check box C3. There is a management ordinance in effect, and it does not require compliance as a result of sale. No point of sale requirement. Simple as that. All right. So summary, what's in your handout, what you need to know. Be sure you check. If you're in a high or very high fire zone, be sure you check that the property is subject to local vegetation management. Go with the boilerplate in 3B unless the seller is aware. And what does that mean? That he has a report. And then finally, C3. Check the box that it's the buyer's responsibility. No, I'm not going to get an inspection. No, I'm not going to bring it into compliance. Now, by the way, the buyer has to agree to this. So that's why we recommend, most agents aren't doing it yet, but the good news is buyers are still agreeing. But to better protect your seller, you should include this FHDS, if you're going to fill it out in this manner, with a counteroffer. That way you're not halfway through escrow and the buyer says, no, I'm not going to take responsibility. I won't buy it unless the seller takes responsibility. Well, the seller's not obligated to do it. You don't have an agreement. Let me suggest, Carr actually opined on this. I agree with him completely. I've actually said this to people. I was pleased that Carr agreed with me. The way the civil code is written, if a buyer and a seller were to close escrow and an agreement such as C3C was not reached, the seller would probably be responsible. So what does that mean? So nobody addressed this, or they didn't agree and they closed anyway. And then 6 months later, the buyer gets an inspection, either a surprise inspection, that's not happening yet, or goes in and gets one and finds out that the property is not in compliance. The buyer would be able to probably make a case that the seller is responsible. So after the fact, the seller could be writing a check, and again, if it's a property in the suburbs of Mira Mesa, you're probably not going to have a high expense. But if it's 6 acres out in Ramona, it could be tens of thousands of dollars to bring the property into compliance. So be sure there's an agreement. And usually the seller will prevail by insisting that I'm not doing it. Buyer, you want to buy my house, you take responsibility. If you don't, I'll find another buyer. But that's negotiable. All right. Now, what you need to consider if you represent the buyer, just like I said, the buyer could find out later, okay, the buyer agrees, so paragraph C3 be my responsibility. And 6 months later, finds out it's going to cost him $30,000 to bring the property into compliance. And that will not be optional, by the way. He will have to, the fire inspector will issue an order to bring the property into compliance. So when you represent a buyer, you might consider making it seller responsibility to do this before close of escrow. Now, back to what I said. You're buying a house in the middle of the suburbs in Mira Mesa, and it just happens to fall right on the edge, because there are a couple of high fire zones in Mira Mesa, believe it or not. Right on the edge there, and it's the middle of suburbs. They don't have any vegetation up against the house. They don't have a whole lot of trees. There's not going to be much of a cost. I want to buy the house. You're buying 6 or 10 acres in Ramona, the buyer might want to go out there and get an idea, what might it cost to bring this property into compliance? He cannot call the fire marshal. The RPA does not allow government inspections, but he could have an inspector who's knowledgeable in defensible space requirements look at his property and advise him as to what he might have to do to that property. My insurance company did that for me. You've all heard the story. I won't bore you with the details, but they informed me that my house was not in compliance. They did that as a precaution, as a precautionary measure on whether or not they would write an insurance policy for me, and they required me to bring the property into compliance. And then they didn't write the policy anyway. So I had to find somebody else. Okay, so keep that in mind. That's in your handout. Okay, let's go back to the laws. The rest of this will go fairly quickly. AB 1033. This is a very interesting law. I don't think it's going to have an immediate impact for quite a while. You'll see why in a minute. AB 1033 allows for a separate conveyance of an accessory dwelling unit, ADU. And so then that was an effort to provide more affordable housing. So local agencies, not required, but are allowed. So the first thing for this to happen is the local agency would have to have an ordinance allowing for the separate conveyance of an ADU. That's the first thing that happened. The ADU would then be transferred as a condominium. The property would become basically a 2-unit condo complex, with the primary residence, one of the units, and the ADU being the other unit. The property sits on, for the most part, would probably be common property, and then each owner would be responsible for their own dwelling, just like many condos that have standalone structures. All right, so the process must conform to certain already existing civil codes. The first one being the Davis-Sterling Common Interest Development Act, which is a very complicated act. And that also has provisions in it on how to create condominium complexes. So you've got to do all kinds of stuff, make a declaration and adopt CCRs, form an HOA. The HOA has specific rules they have to follow. And that's not a simple process. You're going to need an attorney to do this. And it's going to take government approval. It's going to take some time, 6 months to a year, probably. It also has to conform to the Subdivision Development Act because you're subdividing the structures into two separate properties. Each lien holder, if there's more than one, each of the lien holders, if there are any, have to consent to converting the property to a condominium. And then the lien holders, they could require that the liens be paid off or modified, to give their consent. Obviously, they're paid off, they don't have any jurisdiction any longer. And if the property is already under any jurisdiction of any HOA, the HOA has to approve the creation. So you can see that process is not simple. I suspect, the law went into effect, it's already in effect. I suspect that this is not going to be real common, but you're going to have clients ask about it, and you can now give them a little more information about it. By the way, I'm going to, shout out to Lindsay here in the middle of the class. Most of these classes that I prepare are heavily oriented to the forms, or if I'm talking about something, I rely on the forms for my visuals. As you can see, this particular class has a lot of typed information. I'm not a good typist, so Lindsay was a blessing to me this week. She typed up all this, and so I have all of this typed up in a nice Word document. I got to edit it just a little bit because I made a few tweaks after Lindsay typed it, and then we're going to send this out. So all of these written words, you've already got the forms. You're going to get a copy of all of this word for word. What you're looking at, you will get in a document. I'll probably PDF it and then have Lindsay send it out in a day or two. Okay, maximum term for exclusive listing agreements. Some of you are already aware of this. I talked about it when I did the forms class last month. There's some other listing restrictions. Let's talk about those real quickly. The law prohibits an exclusive listing agreement on a residential 1 to 4 unit property of longer than 24 months. So that's the longest. And interesting, it also prohibits renewals of more than 12 months. And it prohibits automatic renewals on any kind of property if it's an exclusive listing agreement. This law was created to combat the most notorious organization was called MV Michael Victor Realty. I think they're out of Florida. They did this in many states. They did this more than Carr realizes. I think I was talking to Carr about this. And they said, well, this law was mostly because of the East Coast. Now, we had property in California. We had at least 2 that I'm aware of where we had sellers, hooked up with this MV and they didn't even know it. What MV Realty would do is contact elderly people, foreign nationals maybe who weren't versed in English language, perhaps, people mostly in financial trouble. And they would offer them money, sometimes as low as $300 or $400. I think we had a client that got less than $1,000. And if you list your property with us, but you don't need to sell it. You don't need to sell it. If you don't want to sell it, you never want to sell it. Don't worry about it. So the seller doesn't know what he's signing. He signs a 40-year listing contract at 6%. And then they record the contract, the listing contract with the county recorder. So the title companies require that be removed. And of course, MV then says, well, I want my 3%, but I'm going to do you a favor. We'll accept a 1% referral fee from an agent you do hire to sell your property. We had to deal with that on 2 separate transactions. So that's why this law came about. Recording an exclusive listing agreement is prohibited. Can't record it. enforcing or attempting to enforce an exclusive listing agreement that is presented for recording. So if you try to record it, the listing agreement becomes null and void. If it's presented for recording, it voids the listing agreement. And if the holder of the listing contract tries to record it once they discover, hey, you listed it with somebody else. Oh, well, let me record this. Even attempting to do it voids any obligation to pay the agent who has that listing. Not the new listing, but the one who's trying to record the listing. Any renewals of exclusive listing agreements must be in writing. Of course, that's, we've been talking about that for quite a while. That's important. Now the civil code's even more specific. Every once in a while, I'll come upon an agent who, oh yeah, they extended. Okay, do you have an extension? No. Well, you need one. Okay. It's got to be dated and it's got to be signed by all the parties. A violation of this law, now this is what's severe. The violation of this law by a licensed person constitutes a violation of that person's licensing law and therefore subjects that person to license law penalties. What does that mean? That means they could suspend or revoke your license to do real estate if you were to try to take a listing exclusive right to sell on 1 to 4 units for more than 24 months. Now, the time period is counted from the date the listing is signed, not from the date the listing goes into effect. So if you sign the listing contract today and it starts next month, then it can only last for 23 months because you've got this month that between the time you signed it and it went, where you actually started to, the listing contract actually went into effect. Exclusions. The 24-month maximum listing period does not apply to owners of property if they are a corporation, LLC, or a partnership. The law went into effect already. The listing contract has already been modified. The modification of terms has already been modified to reflect this law. Online notary service, real quickly, by California notaries. Right now, a California notary cannot do an online notary. And what's sort of confusing is they can't do one online. But the law will authorize California notaries to perform remote online notarizations once the Secretary of State certifies the technology to implement the act, but that must be done not later than 2030. So, hopefully the Secretary of State will get the certification done, figure out what they want to certify and then implement that, spread that out to all of the notaries. That must be done before 2030. Now, in the past, California recognized notarizations done by out-of-state. Right now, out-of-state notaries are doing notarizations. We've had a few, most recently, even in our transactions with our escrow company. That is legal now. It's some of the rules are a little gray. We really require the title company to endorse it, but we're not breaking the law when we have an out-of-state notary notarize, say, a grant deed or the loan documents. Starting this year, the recognition of out-of-state notaries is now firm, and it's expanded and it's strengthened. All right, small claims. I think that's the last one. Small claims limit increases. This is not huge, but it's a little helpful because a lot of disputes, if they have to go to court, can be resolved in a small claims court. So small claims court limits for a natural person, that's a regular person, not a corporation or a partnership, are increased from $10,000 to $12,500. So it went up $2,500. Limitations for non-natural persons, in other words, entities, corporations, LLCs, or partnerships, they are increased from $5,000 to $6,250. So a small increase to allow maybe additional claims that were outside the jurisdiction of a small claims court to be now within their jurisdiction. These limits apply if an individual entity files no more than 2 claims in a calendar year. So somebody who files a third claim, then they're going to be limited to $2,500. That's the maximum amount, and that's to prevent people from just filing nuisance small claims actions, against everybody they meet. Okay. The law already is in effect. It went in effect January 1st. Many disputes between a buyer and a seller are not resolved by the buyers, can now be taken to small claim court, including deposit disputes, assuming the deposit is close enough to 12.5. I would argue if the deposit's 15,000 and it's really an ugly fight, the seller might consider, or a buyer, one or the other, might consider waiving the 2,500 and suing for the 12,500. But that's a business financial decision the clients need to make. Now, a lot of times people argue, well, wait a minute, we have to do mediation and arbitration. No, you don't. Not if you go to small claims court. All car contracts, including the RPA, exclude mediation and arbitration requirements for matters within the jurisdiction of a small claims court. So if you can go to small claims court, you may go there directly. You do not need to arbitrate, and you do not need to mediate. Mediation by itself will cost you $500 or $600. And you don't get a decision, you get an opinion. Folks, that wraps it up. I hope you got something out of this today. Thank you for your attention. And Lindsay, do we have any questions?
Yeah, so we have a question from Sarah Rogue. She asks, would the law exempt flips purchased prior? I think she means prior to January 1st.
Would it exempt? Well, yeah, well, constitutionally, if I'm understanding you, in other words, does this law apply to I closed escrow in December of this past year? Does this law apply to them? Is that what you're asking?
Sarah?
Sarah, you can unmute yourself.
I don't think she's on anymore.
Oh, well, she didn't figure out. All right. But the answer to that question is no. Constitutionally, there's no, you cannot have what's called an ex post facto law. And that means passing a law that makes something you did before illegal. So I think that's what she's asking. So this law does not apply to escrows that are closed. This law it doesn't apply at all right now even. So right now, if you're in the middle of a flip, this law doesn't apply. But again, I would argue, at least at Remax Connections, we don't need this law. This law will help put some teeth in your request to the flipper to provide that information. But all of that information is material and must be provided anyway. It's already in the SPQ. They're going to clean it up, add to it a little bit, add to the SPQ, make it even more, probably reference that law. Because flippers, if you've ever asked for this information, they are very reluctant to provide it. By the way, if you don't get this information, call me. I don't want to jinx myself, but I have never not gotten it. I can be very friendly, but I can also be a little scary if I need to. I can sound like an attorney when I need to. And we'll get this information. So the law doesn't go into effect until July 1. But much of what this law contains, like Carr said, they don't see a need for any new forms. They're just going to, tweak the SPQ a little bit. But the SPQ already contains all of that. Hope that answered her question. And if anybody else had a similar question.
Then Ron made a statement. Can't remember what part of the slideshow this was made in, but it says, but a handyman can't contract for more than $500. So maybe Ron can.
Yeah, no, he's correct. Yeah, you're right, Ron.
So my question is then, can you consider a handyman a contractor if he does over $500 in work? Because basically at that point, I ran into somebody from the licensing bureau one time, and they said, you as a buyer can also be at fault in this, or you as the agent. Now, that as a buyer, whoever had the work done, you would be in violation of the contractor's law. So that's kind of what my question is. You were saying you can say a contractor was a handyman was a contractor. So can you do that?
Well, and again, this is an opinion on my part. It's not been adjudicated to my knowledge. So is there a legal definition of a contractor? I didn't find one. I didn't do an extensive search, but I did a little quick search. And what I think is interesting is, but again, that's semantics. I think what is interesting is there's such a phrase as licensed contractor. So, well, that's different than a non-licensed contractor. And the contractor's license board, by the way, I used to be a general contractor. The license board does make a distinction between a licensed contractor and a non-licensed contractor. So the law talks about contractor and relative to the flipping law, and you have to, if you hire a contractor, you have to tell us who you hired. Well, then the question is, well, what if you hired a handyman? Well, I think you could argue a handyman's a contractor if you had to in court. And so I would advise sellers, if they were my clients, to provide information of who you hired to do the work, regardless of their license status, because the law doesn't say licensed contractor. But you are right, Ron, and you bring up an interesting point. I'll comment on you. You're sort of referencing that, and I think you're being very observant, and that is agents who assist their clients in getting work done on a property. You've got to be very careful how you do that, because you can be violating the contractor's license law. Civil code allows an owner to do as much work on their home as they choose to do. They're allowed to do it. It has to conform to civil code, has to have to pull the necessary permits. But I can build a room addition myself. I'm not going to do it. I'm too old. I don't want to work that hard. Legally, I can do it. I have the knowledge to do it. I'm allowed to do it. I can go pull permits and I can do it. An agent can't do that. An agent can't help a seller hire a bunch of contractors and coordinate all. You got to be very careful. You can, if you're careful, just make sure that all the information, all the signing, all the back and forth, and as far as money and all that, is between seller and contractor and not through you, because CAR and the license board, contractor's license board, not CAR, DRE and the contractor's license board are very sensitive to the fact that some agents are performing contractor licensed activity and they're not licensed contractors. So that you got to be kind of careful of. If you're helping to assist a buyer in hiring a handyman, the fact that you hire a handyman, that doesn't exempt you from possibly violating contractor's license law, because you're coordinating getting these repairs done. You got to be kind of careful. And again, if you're doing for repairs, plumbing repairs, something like that, pursuant to a repair request, you're fine. But if you're getting involved in improving the property, you want to make sure the money doesn't go through you. Make sure you're not collecting a fee for doing that. That sort of address what you're talking about, Ron, as well.
I mean, but as long as they do it free.
Yeah, well, if you do it free, you're a long way to keeping yourself from getting in trouble. So you can advise, you can help, you can guide.
Okay.
Yeah.
Jim Supples said a seller/flipper that purchases the home through an agent will have a TDS and SPQ and other seller disclosures when they purchase the home that will need to be disclosed as well, correct?
Absolutely. Yeah. If I don't, in thinking back what I said, I didn't make that point. I mean, I did make that point about all reports and estimates and that they did. Also, the paper, all the disclosures they got from the original seller, they need to provide that as well. And I would argue that an agent, by law, has that information. And so if the agent who helped the flipper buy the house is also the agent that sold the house, that agent needs to be sure that information is provided to the buyer. We do that at our end. Lindsay gets called every once in a while to get some help in pulling stuff out of an old file. I think now SkySlope is set up where you can go get it. But yeah, if you help somebody in the last 3 years buy a house, we by law have knowledge, constructive knowledge of all those disclosures.
Jeff asks, if you have 3 different estimates for a remodel, are you required to furnish all the estimates even though only one contractor is chosen?
Yes. Yeah. And again, it's sort of, you can be a stickler for every little detail, but on the other hand, the thing that if maybe I shouldn't even say this out loud because I don't want to make this more complicated, but if you have two estimates that read word for word for word, they're probably good to disclose them both. But I was going to say, what is concerned about an estimate is it contains material information. So one estimate suggests, I'll give you a perfect example. We have a problem after close of escrow with drainage on a property. And we've had multiple contractors look at it, and their estimates, they both talk about doing different things. And so if we were selling this property, we would have to provide all those estimates for no other reason than the information contained on one is not contained on the other. Now, the two contractors disagree on the right way to do it, but we're not omnipotent. We don't know which is the right way. So to protect ourselves, we would have to give both of those estimates, and then the buyer would have to contact those different contractors and say, well, you were thinking you should do A, the other guy says do B, explain this to me. So yeah, provide all estimates.
Holly Surway asks, Walt, on the FHDS, what if it's a condo and meets all of those conditions in 1A?
They still have to provide an FHDS. They are not required to do anything to a property that they don't have jurisdiction over. But they do have to answer the questions, and they do have to declare that the property is under vegetation management. They do have to declare they're not aware of any violations, that they haven't had an inspection, and they do need to get the buyer to agree that anything that needs to be done is the buyer's responsibility. Now, the buyer, when he buys a place, and now they say the trees got to be chopped down, that buyer is now a homeowner. He'll go to the HOA, and they'll take care of it. But that's a good question, Holly. It comes up all the time. But condos are not exempt from the FHDS and fire hardening defensible space statutes.
Maria Martin is asking you to please expand on the out-of-state notaries. Is this still allowed, or are there more restrictions?
No, it's allowed. It was always allowed. It was not very well regulated. It is now a little better regulated. So yes, out-of-state notaries, as long as they conform to their state notary laws, are recognized by California. And in fact, the key person, like, there's no California entity that is, judging whether or not the notary is okay. And that, I'll tell you who's the judge and jury on this. It's a title company. So the title company will want to check, and Barb, I think she was on this call. She could jump in if she wants. But what we normally do is make sure that the title company is involved in the fact that we're going to use an out-of-state notary, and they bless it because they're the ones that are going to insure this property. They're the ones that are basically going to allow for the recording.
Yep, that's right, Walt. We've had a couple times where the title companies have said, show us that notary seal. We had one from Florida recently where they wanted more information than was on the common seal in Florida. So, but we'll always check that with an out-of-state notary. It's not a problem.
Yeah, thanks, Barb.
Libby Soleil asks, does being in compliance for defensible space apply to a property inspector report done by the buyer that says there are bushes or plants too close to the house?
Okay, the question confused me a little bit. Are you in compliance? Well, if there are bushes too close to the house, and now who said that? The physical inspector or the fire inspector?
Walt, if you have a physical inspector and they always do they're always saying there's plants too close to the house, and right, your flowers are too close and all that. Does that give the buyer the idea that they should ask the seller to do these repairs so that defensible space is maintained?
Well, yes, I think if I'm understanding your question, the buyer can always ask. I think the point that the buyer needs to be reminded of, and certainly the seller needs to be aware of, and it cuts two ways. There's no requirement for the seller to do that. See, sometimes buyers believe, oh, you have to do that. Oh, you're not in compliance. You have to move, in this case, trim your bushes. No, I don't. I can sell a house that's not in compliance. If I'm aware it's not in compliance, I have to tell you. If I'm not aware, I can say I'm not aware. Buyer, you found out by your inspector, he claimed we're not in compliance. I don't care. I'm not selling the house. Now, in this market, a buyer is probably going to buy it anyway, maybe not. In a different market, a seller might say, you know what, I don't have to bring it to compliance, but maybe I should, because this buyer is paying me 10 grand more than the closest offer I had next to it. It won't cost 10 grand from a few bushes. So great question. The obligation to do anything doesn't exist in civil code. It only exists if the two parties agree.
Well, really quick to expand on Libby's question. So, I mean, a property inspector, when they go in, they're usually saying plants and bushes are too close for the sake of like termite or water. I don't think defensible space really. That's not their knowledge base, right?
That's probably the case because what's interesting, the law doesn't say you can't have bushes too close. The law says you can't have flammable bushes too close. I don't know. I guess if you're a botanist, I guess you could probably tell me what bushes are flammable and which ones are. I do know certain ground covers are not flammable. And I know, I remember reading where, people were, trying to get those kinds of ground covers out in Fallbrook and areas like that because they don't catch on fire. So you're right, though. Usually that being too close is more to do
because of moisture.
With destroying and moisture. Yeah, exactly.
Those are all the questions.
Great questions. You've been a great group. I thank you so much. I'm thrilled that you get on these calls every month. It makes my day. Thank you for being there. And just know you have any questions, don't hesitate to call, text, email. And, don't bat 1,000, but I'm pretty good. I return all my calls. So I will definitely get back with you. Y'all take care.
Thank you
Thank
all.
you.
Thank you, Walt.
Bye,
Well,
everybody.
appreciate your time.
Bye.